Good morning, ladies and gentlemen, and welcome to the Gallagher Law Firm. I'm Keith Gallagher, the principal of the Gallagher Law Firm. I just started my 42nd year of practice in plaintiff's personal injury. Today I want to talk to you a little bit about a very important decision that had just come down from our Nevada Supreme Court involving medical malpractice or medical negligence cases. Now, in some of our previous posts, we've talked a little bit about medical malpractice. We've talked about statutory caps on damages. We've talked about the difference between economic damages and non-economic damages. But one of the things we as plaintiffs practitioners have been waiting for is a decision from our Supreme Court which tells us whether or not all of the legislative enactments by our Nevada legislature are going to remain in place or whether the Supreme Court is going to find them to be unconstitutional. Well, this last week we got our answer. Case of Stephen Tam, MD versus the 8th Judicial District Court. The decision was filed the 1st of October of 2015. And the Nevada Supreme Court, unfortunately for injured plaintiffs, upheld the medical malpractice statutory scheme, has determined that the statutory cap of $350,000 in what are called non-economic damages will be in place. They determined that it applies to the entire case. In other words, if you have 4 injured parties or you have 4 family members of injured parties, $350,000 is the maximum recovery, no matter how many injured parties or plaintiffs there are. In addition to that, the Supreme Court has upheld the rest of the statutory scheme, the statute of limitations, which of course is unique in our state. So it was a victory for the insurance carriers, not so much of a victory for the plaintiffs, but we'll talk a little bit more about that in our next post.